Tonight's event is hosted by the Oregon Community Rights Network. It is also co-hosted by the Community Environmental Legal Defense Fund. The Community Environmental Legal Defense Fund offers a couple different things for communities, legal support as the name denotes, but also grassroots organizing support and training and education services as well. The Oregon Community Rights Network has been around since 2014. It is a statewide group that is made up of local community rights chapters. Similar to the Community Environmental Legal Defense Fund, offers a lot of support to local grassroots organizing for the sake of things happening within various communities there in Oregon, also offering education and training opportunities and trying to host as many of these kinds of events as possible. So we appreciate both organizations putting the time and effort to bring this event to you guys this evening. I'm going to pause just for a second. If people could please put yourself on mute. I'm hearing a lot of noise from various people, and want to make sure that when we do get to the main event here that we could hear our speakers. As you may have read in the information about tonight, we're really talking about a subject matter that in my mind doesn't get talked about very often. When we mention big corporations and we look at the role or influence that they have had on our communities, our ecology, the economy and such, I think it's been fairly easy to discuss that in the realms of the amount of wealth and political power. But an area that does not get discussed very much is the legal reality that in a lot of ways has shaped the modern corporation. And so we thought it was a very important topic. It's a key element to the community rights work that has been going on for a number of years now. And so we invited a couple excellent speakers to speak on the topic about this idea of corporate constitutional rights, how they came to be, what it's meant, the history behind it, I suppose you could say the rationale for why they came to be, and ultimately what's the real impact to our communities, to our environment, when the corporate form has been able to find itself having such tremendous legal powers. What is I guess the ultimate result of such? So we've invited two people here tonight. Very excited that both agreed to be here. They're both going to speak on the topic, but in a couple different ways. So we have two speakers. One is Adam Winkler. Adam is a law professor at UCLA and a specialist in American constitutional law, the Supreme Court and gun policy. His book, We the Corporations, How American Businesses Won Their Civil Rights, that came out in 2018, was a finalist for the National Book Award, the National Book Critics Circle Award, and received the Scribes Award. His scholarship has been cited in landmark Supreme Court cases on the First and Second Amendments, and he's one of 20 most cited law professors in judicial opinions today. His popular writings have appeared in the New York Times, New York Review of Books, Wall Street Journal, Washington Post, LA Times, New Republic, Atlantic, Slate, Scoutist Blog, and Daily Beast. He's a frequent commenter about legal issues and has appeared on Face the Nation, CNN, NBC Nightly News, C-SPAN, NewsHour, ABC News, All Things Considered, Morning Edition, and Marketplace. By that resume, I think we should feel very lucky having Adam tonight. He's a very sought after, busy person. So Adam, thank you very much for making time. Our second speaker here tonight is Karen Hoffman. Karen is an attorney for Serino Law in Philadelphia. Since 2017, she has worked with the Community Environmental Legal Defense Fund to represent communities across Pennsylvania, fighting to protect their environment by advancing rights of nature, including Grant Township, as featured in Rolling Stone magazine, and the full-length documentary Invisible Hand. She also practices immigration law and received the 2019 Pro Bono Award from the U.S. District Court for, I think it's the Northern District, Illinois, for litigation to reunite separated families. So Karen and Adam, thank you very much for being here tonight. We've asked Adam to start us off, to give us really an overview of this idea of corporate rights, where they came from, how that came to be, the realities of that, and then we will have Karen speak to her work in the realm of of really community advocacy and then how corporate rights have come into play there. So I'd like to welcome Adam, I guess, to the podium, so to speak, and start off our evening tonight. So Adam, welcome.
Well, thank you so much for having me. A wonderful introduction. Thank the organizers, the Oregon Community Rights Network and the Community Environmental Legal Defense Fund for having me and for bringing attention to these issues. Also, thanks to Karen Hoffman for joining me tonight, and I'm really looking forward to hearing her insights. You know, when we think of corporate power, we often think of how corporations exert their influence on legislators. You know, through lobbying and generous campaign funding, corporations seize power and win favorable legislation. That's reflected in this famous image, the bosses of the Senate, published originally in the 1880s. And make no mistake, who the cartoonist Joseph Kepler thought was the boss: big corporations and monopolies. And when we think about corporate power, we also have to think about how corporations exert and maintain their dominance through the courts and through the Constitution itself. In recent years, the Supreme Court, in cases like 2010's Citizens United, held that corporations have the same free speech right as you and me, and they can spend their money to influence elections. Now, the only difference is that corporations have a lot more money than you and me, so they can spend a lot more. And some people worry that Citizens United will lead to a corporate takeover of American democracy. Well, you know, I guess in one sense, I think that's kind of silly. I mean, after all, we know corporations took over American democracy a long, long time ago. But seriously, I mean, in my recent book, We the Corporations, I recount the story of how Mora County in New Mexico, population 4,881, passed a law to limit fracking. Here's the Mora County Courthouse, where lawmakers passed the anti-fracking law, and it looks like what you'd expect a courthouse or a state house to look like in Mora County, in this small little rural population, prefab housing. It's not the ornate state capitol that you might have in a big, you know, to represent the entire state. But the law that was passed in Mora County was an effort to really assert some control by the local people over their environment, which was being increasingly threatened by big oil and energy companies. But the companies went to court and argued successfully that Mora County's anti-fracking law violated the company's fundamental constitutional rights. Mora County ultimately had to give up its appeals in the case. With a budget of about $1 million a year, it was really no match for the deep-pocketed companies like Shell Oil, whose annual budget is $270 billion. So the question really comes up, which is, how did corporations come to have our most fundamental rights that they can use to fight off campaign finance law or fight off local efforts to prohibit fracking? Well, of course, corporations do not march on Washington with signs demanding equal rights. Yet, like women and minorities who did march to win their rights, corporations have also fought, as have other civil rights groups, in the courts to get the Supreme Court to recognize their rights. And indeed, corporations have been so successful at this process over the course of American history that today they have nearly all the same rights as you and me, rights that they use to challenge laws that regulate business and the economy in the public interest. In law school today, students are sure to learn about the civil rights movement, women's rights, gay rights, immigrant rights, even states' rights. But there has also been, I wish to suggest, a 2 centuries long history of corporate rights. Now, the first thing to know about the fight for constitutional rights for business corporations is that it's really nothing new. The first Supreme Court case on the rights of business corporations was decided all the way back in 1809. To put that in some perspective, the first Supreme Court case on the rights of African Americans under the Constitution, the notorious Dred Scott case, that wasn't decided until 1857. And the first Supreme Court case on the rights of women under the Constitution, a case called Bradwell versus Illinois, that wasn't decided until 1873. These cases arose over a half century after the first corporate rights case in the Supreme Court. And the corporation involved in that early case was the Bank of the United States, at the time the richest and most powerful corporation in America, with branches from Boston to New Orleans. And this is something that we see throughout the history of corporate rights, that corporate rights have been pushed and pursued by the richest, most powerful, and influential corporations in America. We think of the Supreme Court often as a bulwark for the protection of minorities, but it's often been the handmaiden of the rich and powerful corporations. Now, the heated debate over the controversial Bank of the United States among the founding fathers is often associated with historians as spurring the rise of the first political parties in America. Not to mention, it also gave us a pretty good rap battle in Hamilton the musical, if you had a chance to see that. But the bank was absolutely despised by Jeffersonians, who were determined to kill the bank by any means necessary. And in Georgia, Jeffersonians passed a law imposing a special tax on the bank, and the bank decided to challenge that tax in federal court. The bank's case presented a question that'd be familiar to us today. Are corporations people? Or more specifically, the case asked, are corporations citizens under Article 3 of the Constitution? That provision effectively provides that the courts can hear cases between citizens and effectively gives citizens a right to sue in federal court when they sue citizens of other states. And this constitutional provision sort of reflected the framers' view that state courts might favor that state's own residents over people from other states. And the Bank of the United States, which was headquartered in Philadelphia, argued that it too would be prejudiced if it was forced to litigate the lawfulness of Georgia's popular tax in Georgia state courts. And although there was no evidence that the framers of the Constitution intended this provision, or really any provision of the Constitution, to protect business corporations, the Supreme Court, in an opinion by the legendary Chief Justice John Marshall, ruled that the Bank of the United States did have the right to sue in federal court. Now, Marshall did not say the corporations were citizens as such. Instead, he said that corporations had the right to sue in federal court because corporations were made up of citizens. That even though the bank's lawsuit was brought in the name of the corporation to recover the corporation's property, Marshall said that, quote, essentially the parties in such a case are the members of the corporation. Now, the first case to extend a constitutional right to corporations, Bank of the United States versus DeVoe, is really one of the neglected landmarks of American law. You won't find it in any constitutional law textbook. First-year law students don't read about it. And yet it laid the foundation for 2 centuries of corporations using the Constitution to assert their rights and to defeat efforts to regulate them. By the way, if you think like the right to sue under Article 3 was not a very significant right, remember that was the exact same right that was at issue in the legendary Dred Scott case. The Supreme Court in the Dred Scott case held that African Americans could not be citizens under that very same provision of the Constitution. Unlike racial minorities, corporations did have rights the white man was bound to respect. Now, after the Civil War, the 14th Amendment to the Constitution was adopted, and it was designed to overturn the Dred Scott case and guarantee equal rights for African Americans. Yet, in a remarkable series of cases in the 1880s, the Southern Pacific Railroad Company fought to extend the 14th Amendment's protections to business corporations. And the Southern Pacific Railroad was willing to do almost anything to win. When California in 1879 imposed a special tax on railroads, the Southern Pacific assembled an all-star team of lawyers to fight back. Really, the best lawyers money could buy. The Southern Pacific lead counsel was an illustrious man at the time who we maybe have forgotten today, but at the time he was very, very famous. He was a man named Roscoe Conkling. For nearly 2 decades, Conkling had been a leader of the Republican Party in Congress. He had even been nominated and confirmed to the Supreme Court himself. Earlier, the very same year, he appeared on behalf of the Southern Pacific Railroad before the Supreme Court. He declined to serve, and he remains to this day, by the way, the last person to turn down a seat on the Supreme Court after having been confirmed. Conkling frankly admitted that the reason he turned down the Supreme Court was financial. He was simply making too much money as a lawyer for the railroads. Now, Conkling and the Southern Pacific Railroad's lawyers first adopted a strategy of civil disobedience. The company would refuse to pay the tax. And then the corporation launched a groundbreaking series of what its lawyers called, quote, test cases, more than 60 of them in all, seeking a Supreme Court decision recognizing expansive new rights of equality for corporations. Now, the text of the 14th Amendment did not appear to grant corporations any rights whatsoever. It guaranteed equal protection of the law to persons, not to corporations. But if there's one thing you should know about Roscoe Conkling, it's that he was not the type of lawyer who'd allow a little thing like the text of the Constitution to get in his way. And Conkling told the justices that when the committee that wrote the 14th Amendment chose to guarantee equal protection of the laws to persons, quote unquote, he said that it was designed to, quote, and this is what he said to the justices, embrace artificial persons as well as natural persons. Now, of course, this was an audacious argument, but Conkling was uniquely situated to make it. As a young congressman, Conkling had served on the very committee that had drafted the 14th Amendment. Indeed, by the time he was standing before the justices of the Supreme Court making his argument, he was the last surviving member of the committee. So there was no one there to refute his story. Conkling even produced a musty old diary that he said was a never before published journal of the drafting committee's deliberation, but that if you looked at the journal, it would support his story. Now, there was just one small problem with Conkling's account of the drafting of the 14th Amendment. It wasn't true. We now know that the language of the amendment had never been changed the way Conkling claimed, nor do the records show that any member of the drafting committee ever said or even implied that corporations would be protected when the amendment was proposed and ratified. As one historian who examined the evidence closely concluded, the trusted Conkling had engaged in, quote, a deliberate brazen forgery to win new rights for corporations. Now, the Supreme Court never ruled in Conkling's case, actually. It held on to that case for 3 years without ever issuing a final decision. Some said it was due to a procedural snafu, although I suspect Conkling's fraud was uncovered. Regardless, another one of the Southern Pacific's 60 test cases made it to the Supreme Court a few years later, this time with no Conkling. And yet, the shenanigans continued. In this second case, the court ruled in favor of the railroad, although not on constitutional grounds. The court expressly stated that it was not deciding whether corporations had 14th Amendment rights. But then the Southern Pacific test cases took another bizarre turn. The court's opinion are published in official volumes. That's what I have up here on the screen here. These are official volumes. They're edited by someone called the Reporter of Decisions. And traditionally, the Reporter of Decisions writes up a summary of each decision describing the court's reasoning and publishes that summary together with the opinion in the official volumes of the Supreme Court. And this is designed basically to make legal research easier. Lawyers can easily look over the summary and quickly understand what did the court decide. The Supreme Court's reporter back in the 1880s was a man named J.C. Bancroft Davis. And Davis' summary of the Southern Pacific case said that the court had ruled, quote, the defendant corporations are persons within the intent of the clause in the 14th Amendment, which forbids a state to deny any person within its jurisdiction the equal protection of the laws. It's probably too small for you to see on the screen, but it's there. Now, we don't know what motivated Bancroft Davis to publish such an inaccurate summary. But if you're one for conspiracy theories, you might be interested to know that Davis had once served as president of the Newburgh and New York Railway Company. Now, an unscrupulous and ideologically driven justice by the name of Stephen Field, who feared the spread of socialism, saw the opportunity Davis's inaccurate summary presented. Now, Field, if you've never heard of him, was really one of the most colorful justices ever on the Supreme Court. He was the first justice from the Wild West, from California, and he was reputed to carry a gun with him at all times, even under his judicial robes. He's also the only sitting Supreme Court justice ever arrested for a crime, and the charge was murder. He was innocent, of course, But maybe we could say he was guilty of one thing, which was he was doggedly determined to extend 14th Amendment rights to corporations to protect them from government regulation. And when the Southern Pacific case was handed down, Field wrote a separate opinion criticizing his colleagues for failing to rule on the important constitutional question. Nonetheless, in a majority opinion a few years later, Field cited the Southern Pacific case and the inaccurate headnote and wrote that the court had indeed ruled in that earlier case that corporations had 14th Amendment rights, something Field clearly knew to be untrue. And in the years to follow, the Southern Pacific case would be cited over and over again for holding that corporations had rights under the 14th Amendment. Now, one reason Field was able to get away with this sleight of hand was that he nevertheless captured the spirit of a court that was heading into what was known as the Lochner Era, a time period that lasted from roughly the 1890s to 1937, during which the Supreme Court struck down a lot of laws regulating businesses, including child labor laws, zoning laws, minimum wage laws. Meanwhile, the same Supreme Court, in cases like Plessy against Ferguson, was refusing to read the 14th Amendment to provide any meaningful protections for African Americans, the amendment's intended beneficiaries. Indeed, between 1868, when the 14th Amendment was ratified, and 1912, the Supreme Court decided a total of 28 cases on the rights of African Americans, and an astonishing 312 cases on the 14th Amendment rights of business corporations. The 14th Amendment, adopted as a shield to protect the rights of the most vulnerable minorities, had been transformed into a sword used by wealthy and powerful corporations to strike down regulation. Now, while the Lochner Court was a very friendly court, the court, the justices of that era also imposed some boundaries and limits on the rights of corporations. In a 1905 case, the Supreme Court said that corporations had property rights, but not liberty rights. Corporations needed basic protections for their property and their assets, but the courts refused to extend corporations those rights that were associated with personal autonomy, conscience, or political freedom. In a case evocative of recent controversies over businesses that refused to sell wedding cakes to same-sex couples, claiming that the companies have a right of religious freedom, the Supreme Court in 1907 held that a corporation did not have a constitutional right to refuse to serve unwanted customers. California had passed an early anti-discrimination law requiring places of public amusement to admit anyone with a valid ticket. That law was challenged by a corporation that ran Tanforan Racetrack, later home of the legendary Seabiscuit, and more disturbingly, Fred Korematsu during the internment. And the company claimed that the law violated its freedom of association, calling it the equivalent of requiring a host to admit unwanted guests to his private reception. Nonetheless, the Supreme Court upheld the law, calling the asserted right a liberty right, not a property right. The court said this was not the type of right that corporations should have. In another instance of deja vu, corporations like the Lansing Brewing Company challenged campaign finance laws limiting corporate money in elections, nearly a century before Citizens United. In the early 1900s, some of the earliest campaign finance laws were adopted, and they were included in bans on corporate spending. Yet in the run-up to Prohibition, the Lansing Brewing Company wanted to influence local elections on whether to go dry, and the corporation challenged the constitutionality of these corporate spending bans. Yet the courts consistently upheld the campaign finance laws, explaining that the right to influence election was a right limited to natural persons. Now, not all corporate rights are necessarily bad, mind you. Consider the case of the Louisiana newspaper corporations that fought against the censorship of the demagogue Huey Long in the 1930s. Now, Long was really Trump before Trump. He was a boisterous, outspoken populist elected on the eve of the Great Depression, promising to make Louisiana great again. And Long became angry when the mainstream media in Louisiana opposed his agenda. Long accused the Louisiana papers of publishing fake news and stuck them with a tax on their advertising revenue. Long said his tax should be called a tax on lying, 2 cents per lie. Now, the newspaper companies challenged Long's tax in court, But the law at the time appeared to be on long side. The Supreme Court had previously said that the freedom of the press only prohibited what was known as prior restraints, restraints of speech in advance. But the advertising tax wasn't a prior restraint. It was just a burden that the corporations had to face. The Supreme Court nevertheless issued a landmark ruling in favor of the newspaper companies. The court held that the freedom of the press protected against any form of censorship, even if it wasn't a prior restraint. And corporations, the court said, were entitled to claim that right too. In a modern society, newspapers played an essential role in checking the government and encouraging democratic debate, and they were published by corporations. In the years to follow, corporations would be involved in many other landmark freedom of press cases, including New York Times versus Sullivan, which established the right to criticize public figures, and the Pentagon Papers case. Indeed, if you enjoyed the recent movie The Post, you were likely rooting at the end for a business corporation that was asserting its First Amendment rights. Now, by extending First Amendment speech and press protections to corporations, however, these cases blurred the boundary between property rights and liberty rights, with corporations now having a toehold in the First Amendment. Now, the free speech rights of business corporations expanded greatly in the 1970s, and strangely enough, Ralph Nader inadvertently helped it happen. The famed Crusader won a groundbreaking Supreme Court case on behalf of consumers in 1976. That case struck down a law prohibiting pharmacists from advertising the price of prescription drugs. Now, Nader's goal was to help consumers who were often overcharged for their medications, and because of the law, could not easily comparison shop and find the best prices. But Nader's victory established two First Amendment principles that have since been used to great success by business corporations. The first principle was that speech on commercial matters like advertising was protected by the First Amendment. Previously, the court had rejected the idea that commercial speech was covered by the First Amendment at all. But under the new doctrine that was pursued by Nader, the court ended up empowering corporations to challenge a wide variety of laws, including laws mandating graphic warnings on cigarette labels, laws requiring public companies to disclose the use of conflict minerals, and laws restricting the advertising of alcohol and gaming. Thanks to the commercial speech doctrine, about 50% of all First Amendment lawsuits today are brought by business corporations or trade associations that represent business corporations. Recently, the head of Nader's public interest organization called for the entire line of cases growing out of Nader's victory to be overturned, a poignant example, I think, of how big business perverts progressive reforms. Now, the second principle established by Nader's victory was that the First Amendment protected the rights of listeners, and not just the rights of speakers. Nader represented consumers in his cases, not the businesses that sold to them. So he didn't argue that the law infringed the speech of pharmacists. Instead, he argued that the law restricted the rights of consumers to hear what the pharmacists had to say. The Supreme Court agreed with Nader and adopted what's been known since as the listener's rights view of the First Amendment. But that theory would quickly be used to strike down, for the first time, laws restricting corporate money in politics. 30 years before Citizens United, the Supreme Court first struck down a campaign finance law limiting corporate spending in a case called First National Bank of Boston versus Bellotti. The case involved a Massachusetts law that prohibited corporations from spending their money to influence ballot measure campaigns. The majority opinion was written by Justice Lewis Powell. Just prior to joining the court in 1971, Powell had written a memorandum for the Chamber of Commerce outlining a program for the political mobilization of business. It was the era of Nader, consumer rights, and environmentalism, and Powell's memo was a call to arms for business leaders to fight back and preserve the free market. Powell's memorandum ended up being widely shared, and today historians credit the memo with inspiring businesses to become much more politically active. And in the Bellotti case, Powell had the opportunity to turn his memorandum into constitutional doctrine, to write it effectively into the First Amendment. Powell's judicial papers show that he was able to secure the votes of a majority of justices by adopting the listener's rights approach to the First Amendment. When justices objected, we shouldn't say that corporations have the same free speech rights as individuals. He convinced them instead to agree that no, As a result of Nader's victory, we now should focus on the rights of listeners. And asking whether business corporations had political speech rights was what Powell called, quote, the wrong question. The campaign spending law infringed the rights of listeners to hear what corporations had to say. The identity and rights of the speaker, Powell wrote, were totally irrelevant. Listeners' rights would also be used in Citizens United. The 2010 decision struck down a law barring corporations from spending their money on election ads. And surprisingly, for all of the debate about whether corporations are people, Justice Anthony Kennedy's opinion for the court never said that corporations were people. Instead, Kennedy's opinion relies on the listener's rights theory that was first articulated by Ralph Nader. And he argues in that case that the identity of the corporate speaker was irrelevant. All that mattered was whether the law at issue restricted the type of speech, political speech, that was entitled to protection and that listeners were entitled to hear. So fueled by the capital amassed with the corporate form and represented by the bar's highest paid lawyers, corporations really have been fighting for equal rights for more than 2 centuries. They've used the courts and the Constitution to strike down business regulation and to secure their freedom in the marketplace. Cases like Citizens United have brought the issue of corporate constitutional rights to our attention. But Citizens United is really only the most recent chapter in a much older story. It's the story of what we might call the corporate rights movement, one of the least known, yet perhaps most successful civil rights movements in American history. Thank you.
Thank you very much, Adam. We are going to hold questions, or as I mentioned, you can put questions in the chat and we'll get to them here in a second. We want to hand over the microphone to Karen Hoffman to talk about sort of the on the ground in community reality of what Adam laid out so beautifully around the ability of corporations to utilize those bundles of constitutional rights, and what does that mean when a community comes up against that? So beyond just the issue, the fact that they have such force to assert their will against the will really of the community. So Karen, I would like to welcome you to talk about your experience there in Grant Township and perhaps elsewhere. And after you're done, we'll get to questions.
Thank you so much. Thanks, Kai and Nancy and the ORCRN. Thanks to everyone who's joined, and thank you, Adam. I learned a lot. It's been a minute since I took con law, so thank you for that refresher. So as Kai mentioned, I'm a lawyer based in Philly. I've been working with CELDF since 2017. And I'm going to talk about one of our clients, Grant Township, that has been fighting a long and drawn out battle with a gas company, Pennsylvania General Energy, which PGE, and talk about, everything that the professor just mentioned, but how it's being used as a bludgeon against this town of 700 people. So Grant Township, it's a tiny town in rural Pennsylvania. It's important to know that there's no public source of drinking water. Everyone has their own private well, or they get it from a spring. And they were sued by PGE because they passed an ordinance banning the disposal of fracking waste in their township. And there are some other lawyers on this webinar that were also on that case, so I hope they will jump in if I get something wrong. But that was back in 2014 when this all started, and PGE, part of the basis for their suit was that Grant had violated their alleged corporate rights. So PGE engaged in fracking, had this produced water, this waste to dump, and they wanted to use an old well in Grant as an injection well. And as I'm sure you know, injection wells can cause a lot of problems. They have caused earthquakes. There's an issue of the trucks bringing in the chemicals at all hours. But most importantly, for Grant, the issue was the toxicity of the waste, because it's got all kinds of chemicals in it, some of which the regulatory agencies don't even know what they are because they're trade secrets. And some of the most concerning are the radioactive materials. And there was a great report. I don't know if you're all familiar with an outlet called Public Herald, but they just came out a few days ago with this really great whistleblower report on focusing on like the radioactive materials in fracking waste, and yeah, about how the Pennsylvania Department of Environmental Protection has utterly failed to protect Pennsylvanians from it. So one of the substances in fracking waste is radium-226, and it's in even DEP in its own study found that it's in that waste at like 5,000 times higher than the limit for drinking water, and it sticks around. Its half-life is 1,600 years. So I mean, once something goes wrong, once there's a leak into the drinking water, you can't just put it back in the bottle. So that's why Grant resolved that they would protect their water. They passed this ordinance in 2014. They got sued by PGE. And so it was a Section 1983 lawsuit by the company alleging violations of their constitutional rights. And those were the Supremacy Clause, Equal Protection, the First Amendment, specifically the Petition Clause, substantive due process, procedural due process under the 14th Amendment, and the Contract Clause. And it's a very long and complicated case, but I'll just sort of hit the basic highlights or lowlights. So the court first invalidated provisions of the ordinance based on state law. And so they basically knocked out the parts that were banning the frack waste. And at that point, Grant Township decided they were going to become a home rule municipality. And that gave them the power to pass a charter, which has this basic effect of state law. And so the charter went ahead and did the same thing. It banned the frack waste disposal. But so even though the ordinance was basically null at that point, this litigation over it continued. And so, yeah, among other things, PGE got the court to sanction 2 of the attorneys representing Grant Township, the CELDF attorneys, for $52,000 for, among other things, challenging corporate rights. And as far as the constitutional claims, on a motion for summary judgment, the judge granted half of them for PGE. So they granted the equal protection, if you can believe it. I'll talk a little more about that, and the First Amendment and the substantive due process. So yeah, as Adam mentioned, we have, I guess, Roscoe Conkling to thank for that equal protection interpretation, but it really on its face, it just makes no sense. You know, so he mentioned the Mora County case. So in the Mora County case, the court found that it did not make sense to apply equal protection to corporations because you would rationally not pass a law banning like corporations and individuals from fracking because individuals don't frack. You know, only corporations are going to do that. But the judge in the PGE Grant Township case did not agree with that and found for PGE that even though Grant Township had a legitimate goal in its ordinance, being that the depositing of oil and gas waste threatened the residents' rights to clean air, water, and soil, threatened residents' rural quality of life, threatened the ability of ecosystems within the township to exist, flourish, and naturally evolve. So the court said, while those goals are legitimate, there's no evidence of a rational relationship between the disparate treatment of corporations and the stated goals of the ordinance. If these goals can be achieved only through the elimination of fracking, it makes no constitutional sense to allow the same activity by individuals. So just a completely, in my opinion, nonsensical interpretation of equal protection. But yeah, so that was one of the ones the court found summary judgment for PGE. And as I mentioned, there were 3 that they denied it. But so the case was set to go to trial on those claims and on damages. And then the parties wound up settling, and Grant paid nominal damages of $1. So then there's a whole saga about what happened next with the court granting attorney's fees to PGE. So under Section 1983, which is this kind of, you can sue for your constitutional rights being violated, there's a accompanying provision, Section 1988, which is a fee shifting statute. So that means it's meant to encourage, I mean, the whole legislative history of it, it's meant to encourage indigent civil rights plaintiffs who can't afford to, hire a lawyer, go to court, to bring these kind of cases about their violations of their actual constitutional rights. But it's been twisted, of course. So here PGE is using it and saying this tiny town of 700 people should pay them hundreds of thousands of dollars in attorney's fees. So this judge granted that, awarded the large fee award, and Grant Township appealed that to the Third Circuit. The sanctioned attorneys appealed the sanctions. PGE cross appealed the sanctions and asked for even more sanctions against the attorneys and CELDF to the tune of $600,000. And I mean, in all of this, it was known that Grant Township had, they repeatedly said, they were very open about the fact that they did not have the resources to pay this. Regardless, what wound up happening is it was settled at the Third Circuit. Grant Township didn't pay a cent. And then just to do a little detour into a case that at the state level against Grant, which is also going on. It doesn't directly involve corporate rights, but it's an egregious part of this case, which is, so not only do you have this gas company suing the small town for passing this ordinance, then in 2017, you have the State Department of Environmental Protection suing the township for passing the charter. And they said it was preempted by state law and that DEP is the only, they have the authority to protect the environment, not this township. So Grant Township sued them back and said that the charter is a valid and necessary enforcement of their rights to a clean environment, clean drinking water, and that DEP is failing to protect them. It has a duty as a public trustee to protect the environment. It's failing to do so, and so Grant had to step up. And so for years now, DEP has been trying to get Grant's claims dismissed, and they've failed each time. So then finally this spring, the DEP wound up rescinding the permit that they had given to PGE to dispose of the frack waste, and they cited the charter as an applicable local law. Now PGE has appealed that to the State Environmental Hearing Board when it's pending. And in one of their filings to the board, they say they're complaining that they're trying to sell this well now, but no one will buy it because of the charter. So, and then the coda on all this is that this past week, PGE sued Grant Township again in the same district court as before. This time they sued over the charter. This was all about the ordinance last time. And they're making the same constitutional arguments. They're trying to invalidate the charter and enjoin Grant from enforcing it. So I would just end by saying that throughout all this, it's been going on for 6+ years at this point. The Grant Township supervisors and the people of Grant have been holding strong, and it's really been a privilege to represent them, and that there's still no frack waste injection well in Grant Township. Thank you.
Karen, thanks a lot. And Adam, thank you very much also for laying the groundwork to set Karen up. We've had a few questions come in, and hopefully we'll get a few more. I'm just going to go through from first to last. So someone asked, and either of you can jump in on this, asked if there's any way to stop corporations from lying or doing false ads. I don't know how you might want to tackle that, but if you have any sort of advice or response to that, please chime in.
Well, certainly, I mean, the Supreme Court has said that states can prohibit false or misleading advertisements about commercial products. However, because corporations have really been getting expansive political speech rights, the court has historically been very reluctant to say something is misleading or false in the political context. Instead, preferring a kind of free market approach to free speech, where the court says, we will let the marketplace of ideas determine what's true and what's false through the battle of the marketplace. The fact that they use that marketplace metaphor is no real accident. And corporations are now able to use sort of the marketplace and political spending to really influence voters, often with misleading speech. We see this a lot, especially in the referendum and initiative process, when ballot measures are proposed by corporations and they mislead the American people and the people of that state to win sometimes those ballot measures. So while states do have the ability technically to regulate false and misleading speech, when it comes to politics, that becomes much harder. And increasingly, corporations will say that their speech is really about politics and not about commercial goods.
We have another question around sort of corporate influence in the political realm. This one is, even if we can control direct corporate funding for politics, can we stop them from funneling it through shell nonprofits? So I don't know if you want to talk about whether or not the law sees a distinction between for-profit and nonprofit when we're talking about constitutional rights.
Well, Karen, definitely jump in if you want to address any of these issues, of course. But certainly one thing we need to recognize is there is a difference between different kinds of corporations. There are for-profit business corporations, but there are also nonprofit corporations. The NAACP, the ACLU, there are organizations that are used the corporate form. There are also universities, churches that use the corporate form. And I think what that does is does highlight that we have to have kind of a nuanced approach to how we think about corporate constitutional rights. With regards to taxing, I mean, we could tax political spending, but the Supreme Court has generally said that any kind of special burden that you pose on political spending is a kind of form of censorship. And especially when it comes to political speech that's at the heart of the First Amendment, then we don't want to accept things like special taxes on First Amendment speech. I don't think the answer is to limit political speech. A better answer is to figure out and have the Supreme Court agree to rules that recognize that there's a big difference between corporate spending in election and the spending of ordinary people in elections, and to recognize that equality and pursuing equality is an important principle of campaign finance law. I don't know whether money is speech or not, but we shouldn't allow people to spend unlimited amounts of money on speech.
Karen, anything to add just on your experience around these questions of corporate influence in politics and the approach to, as Adam sort of put it, how do you contain that or rein that in, or make sure that living, breathing human beings are heard more so than commercial interests?
With this Supreme Court, I'm not sure. And I wanted, as you were talking, Adam, I wanted to ask a question. I don't know if that's allowed, but what you see the direction of this court going as far as like, are we going to have, a bunch of brand new corporate constitutional rights, or where you think it's headed?
Oh, I think there's no doubt that this Supreme Court will expand the rights of business corporations. We've already seen it in the Roberts Court before the addition of Justices Gorsuch, Kavanaugh, and Justice Barrett. Right, it was the Supreme Court in 2010 that issued Citizens United expanding political speech rights. Supreme Court in 2014 that expanded the religious rights of companies like Hobby Lobby to refuse to offer birth control for their employees on the basis of the corporation's religious beliefs. And in fact, I think that's one area we're likely to see an expansion of corporate rights going forward. I think the Supreme Court's likely to say that corporations have, even private for-profit business corporations, have expansive religious freedom rights so that they can refuse to provide services for LGBTQ people, same-sex couples, etc., if it offends the owner's religious beliefs. So I think we're going to see an extension of corporate rights in that space. I think we're also likely to see the court expand commercial speech protections and to provide corporations even greater protections against government regulation when they are advertising. I think those are two areas where we're likely to see corporations gain rights in future years. I know that some people have asked in the comments and the questions in the chat about what we could do to overturn those Supreme Court decisions. I mean, ultimately, you could do it with a constitutional amendment, or you could do it with new Supreme Court justices who have a better sense of what the rights of corporations should be. And so probably reform needs to try to happen on both those tracks.
Yeah, I think you mentioned it in your book, Adam, and our work on a day-to-day basis, we try to get people to understand that the Constitution clearly lays out ways of which the Constitution can be ratified, but what's not often understood is how the Supreme Court actually, in making certain decisions, does that ratification, so that there's this other means of which constitutional rights have expanded, in this case for the corporate form. Someone had mentioned or asked about Grand Township in specific. I think, Karen, you mentioned at the end that nothing has happened around the injection well going in. So their now 6-year battle on the grounds of keeping the toxic waste out has been successful, despite their legal fight continuing, and unfortunately, in large degree, the court's not recognizing the ability of communities to self-determine and protect their communities there. So I don't know if you have any other additional sort of Grant Township facts or information that you want to bring in that might be interesting for people to know about.
Well, I mean, one reason that this has sort of kept going at least in the state court for as long as it has, and like I mentioned, that Grant was able to beat back a lot of these challenges from the DEP, is there's a Pennsylvania has an environmental rights amendment in its constitution, its state constitution, that has been part of the arguments that Grant Township has been making. And the court, at least this far, has declined to boot out the case based on that. So, I know Pennsylvania, groups in Pennsylvania are looking really heavily at that amendment. It's not a panacea because, of course, the courts are the ones that interpret the Constitution, and so they can decide it means nothing, or that it means what it says. But at least up until now, that's been an important part of the story as far as why Grant has been able to hold out with the charter as long as it has. So I mean, we'll see, obviously where things go from here, but that I thought should be mentioned.
Adam, you jumped in on the question of just the means of which these Supreme Court decisions could be overturned. I know this jumps into more the political realm versus the legal, but for both of you, actually, what's your sense of congressionally things changing, meaning that Congress could adopt or propose amendments, let's say, or propose new ways of looking at the corporate form versus arguments in court? What's your sense of there? And again, I know we're dealing into the political realm, but I'm assuming both of you in your own practices, and Adam in doing your book, that the legal stuff and the political stuff blurred. So you may have some thoughts there.
Yeah, I mean, I think that the possibility that the Supreme Court is going to overturn or restrict corporate rights is really not very good in the near term. Like we've talked about and Karen mentioned, the Supreme Court's becoming stronger on this issue, not weaker, with the new justices that are likely to be there for some time. Perhaps you could see significant Supreme Court reform in coming years. I think it's highly unlikely that there'll be new justices added to the Supreme Court, but that's a possibility. If that kind of significant Supreme Court reform were to happen, I imagine that you could appoint justices who have a more skeptical view of corporate rights than we've seen under the current court. But like I said, I don't think that's really likely. There is an effort to amend the Constitution and to do it through constitutional amendment. A bunch of organizations have been out there, including an organization called American Promise, which is kind of leading the charge for a constitutional amendment to restrict corporate rights, at least in some way, shape, or form. Again, that's a difficult thing to do. It's hard to amend the Constitution, but I think it's important to pursue all of those. And I even think it's important for Congress to pass legislation articulating constitutional vision on this issue, saying that business corporations should be treated differently, and passing new laws that restrict corporate political spending, for instance, even if the Supreme Court's going to turn it down eventually. I think it's important that a movement use every tool available to mobilize people, to bring the issue to the forefront, to push legal change. Look at what's happened in the Second Amendment area. Look what gun rights advocates have done over the last 30 years to change the popular understanding and the constitutional understanding of gun rights. They've been really, really active and really effective, because they fought on every turn at every battle they could. And I think reformers that want to fight corporate rights have to do the same.
And I would just add to that maybe it's because of the Supreme Court being kind of a dead end at this point for the foreseeable future, maybe it's time to think more seriously about action outside the courts, just to avoid running up against that kind of challenge. So in addition to, legislation, as Adam mentioned, I mean, you all know, you're activists in your communities, like there's a lot that can be done without getting the courts involved at all. So just wanted to throw that out there.
There's a question that came in about privileged property. And the question specifically is, what are your thoughts on this concept and how it relates to our current discussion? So the idea, I guess, of the power of property and that how the Constitution has protected property to the level that it has, and then how, the constitutional rights of corporations related to property, what's the I guess the interrelation there, or thoughts on that particular question?
Sure, I'm happy to address that. I mean, I think that corporate property rights are really one of the most important features of the constitutional growth of corporate rights. In that property rights were what many corporations were asserting when they went to the Supreme Court and fought regulations. And we should have no misconceptions about the Constitution. For a generation like me that was born, post Brown versus Board of Education, we kind of have this sense that maybe the court is really there to protect minorities and the most vulnerable and protect our most important civil rights like speech and religious freedom, when so often, in fact, the court has really been there to protect property rights, the rights of property and the rights of property holders from having we the people impose regulations on those property rights. And so that's really important. At the same time, I think that many people would not be very upset at the basic concept of corporations having property rights, in the sense that, Coca-Cola owns its factories, say. It would seem wrong if the state of Atlanta were to decide that we're just going to take away Coca-Cola's factories, make them a public company, a government-owned company, and not pay any just compensation. If the government's going to take your land, then the government generally has to pay money for that, fair market value. And I think that kind of property right doesn't disturb a lot of people. In fact, more disturbing is when corporations use powers like eminent domain to take the property of ordinary citizens and give it to big corporations, where it's more troublesome. But it just highlights that property rights are a big feature of American constitutional law, and it's part of the way that we protect privilege and wealth that has been gained over the years, often on the backs of others, in corporations and wealthy individuals, very strongly.
A question that came up on term limits. I'm not too sure if I'm assuming term limits on Supreme Court justices. Any thoughts on the likelihood of that kind of notion coming forward by either party?
I mean, I think both parties, as long as we only have two major ones, they're both going to press their advantage when they have it. And so whoever's in power at the time, I don't see allowing that, but could happen maybe.
Yeah, and a lot of people have talked about that as a potential Supreme Court reform, 18-year term limits. The idea is it would really help the confirmation process a little bit, because every president could depend on getting at least 2 appointments to the Supreme Court, because someone would be retiring every 2 years. But that is maybe a reform for the confirmation process. Doesn't tell us anything about who's getting appointed to the Supreme Court and whether those justices will be corporate friendly or not. The truth is our Supreme Court today is the most business-friendly Supreme Court we've ever had in American history, according to studies of political scientists and others, just more likely to rule in favor of businesses and against consumers and against the public and against business regulation. We need to change that attitude in the Supreme Court. And we should recognize, by the way, it's not just a left or right issue. Justices on the left and justices on the right have often voted for expansive rights for corporations. And so it's really about changing the attitude and maybe thinking about different, rather than how many years we appoint people, whether we can get people from more diverse perspectives on the Supreme Court, not just judges and corporate lawyers, but people who are public defenders, people who were reform activists. We need people like Karen Hoffman on the Supreme Court, bringing her background to the cases that are being decided, and not just corporate lawyers like Lewis Powell.
Karen shook her head. She wants to be the second nominated Supreme Court justice to refuse her seat there. So
I was inspired by Roscoe.
The question came in around the rights of the environment or rights of nature, specifically if the Supreme Court has heard cases around there. And I wanted to maybe expand on that question to ask both of you the likelihood of, as we know, corporations aren't mentioned anywhere in the Constitution, but they've been able to make the argument that they're seen as persons or have other non-personhood rights under the Constitution and been successful at that. Clearly in American constitutional law, we've had unenumerated rights recognized, the rights of privacy. So in the course of, let's say, the environment being seen as having rights under our current Constitution, what's the path sort of look like that, or what's the likelihood if such a right were to be argued and make it to the Supreme Court eventually?
I just pasted in the chat just sort of a timeline that CELDF has put together about different rights of nature laws and cases. To my knowledge, no, it has not been at the Supreme Court. But yeah, I don't think it's out of the question by any means. I mean, everything seems impossible until it's happening. And there's been, I mean, the entire history of jurisprudence at the Supreme Court expanding rights was only because these kind of like crazy ideas were argued. So, you know, at one point, I mean, everybody knows the history of this country and who had rights and who didn't, and how that's gradually been expanded. So I don't think it's pie in the sky to think that it would come up and potentially be a winner. I just, I mean, realistically with this court, no, I don't see it. But it has been, you know, at different circuit courts in different kinds of cases. So it's out there. The arguments are being made.
And interestingly enough, a lot of the arguments that are being made, and we've seen it in foreign countries being adopted, where rivers have been protected. I'm sure that's in the link that Karen put out there in the chat, where rivers have been protected. We've seen efforts to try to protect animals, such as chimpanzees, by and giving them and recognizing them as having rights. And interestingly enough, is that one of the tools that is often used to try to pursue the rights of nature, the rights of a chimpanzee, is that idea of personhood. That idea that personhood under the Constitution means that you have rights, that you have rights like you and me. And in the same way that a corporation can be a person, the argument is that a chimpanzee can be a person as well. It wouldn't mean that the chimpanzee has all the same rights as you and me. That would be a little odd, of course. I'm not expecting to see a chimpanzee come and exercise the right to vote. But it is saying that if a chimpanzee is a constitutional and legal person, then it can have rights, like a right of due process that would protect it from being kept in captivity for its life. Or the river might be deemed a legal person and have a right to protection and a right to safety from pollution. Yeah, is it going to happen tomorrow? I don't know, but it's interesting how that it borrows from that same notion of personhood that corporations have used to win their constitutional rights.
Yeah, there's an interesting essay that's also for those looking at environmental law from actually someone that taught at the school you are right now, which is by Christopher Stone, Should Trees Have Standing, you know, speaking to the idea of how hard it is to conceive of the rightless having rights if you're the one that has rights, so that cultural shift takes place beyond just the legal realm. I don't know if you guys are catching up on chat at all. There's a question from Mark and Katie. I'll read it to you if you didn't read it. It said, I can't see the legislators who have any amount of power. AOC says, though, that she's supported by the people and not corporations, will be willing to bite the hand that feeds them by voting against or imposing regulations that don't benefit their benefactors or corporations in general. Will you please speak to that and the potential of transformation in this area? So again, this idea of corporate influence at the highest levels of our government.
I mean, I think this is a major, major concern and really one of the real burdens that reformers confront, which is that it's just sort of a natural thing that elected officials generally want to bring economic growth to their communities. And that means that by their very nature, by their very inclination, they want businesses to come in and bring jobs and bring tax revenue. And it's one of the reasons why corporations are so powerful. Even if they weren't spending their money on political ads, even if they weren't lobbying all the time or excessively, they would still end up having a lot of influence because elected officials want the economic growth that's often associated with corporations coming in and bringing jobs. And in fact, it's one of the real disastrous things I think that's happening in America right now is that we have states and local communities that are negotiating against other communities and states to provide corporations the most attractive set of subsidies, tax breaks, breaks from regulation that apply to other businesses in the area as a way of enticing companies to come to their community and bring those jobs and bring that tax revenue. Unfortunately, I think many of these states, it's kind of a race to the bottom. They're giving away all of the benefits, the economic benefits that they think are really going to come from the corporation through these subsidies and tax breaks. And it's not a great situation for America where a corporation could just set one town off another to try to negotiate the best deal for the corporation and the worst deal for the American citizen.
I mean, I would say that I guess the silver lining of things getting steadily worse economically for the majority of people in this country is that we are seeing more and more progressive type candidates that do reject corporate funders and at all levels, even presidential. So I'm encouraged by that, and I think there is hope for a significant, at least a block within our current system of politicians that aren't beholden and that, hopefully don't sell out once they get in power. And I did want to say, and I would actually be interested to hear what Adam has to say about this is, as one solution to this sort of like block that corporations have on power. I mean, going back to like the origins of corporations and, there's a charter that forms them. And, what about the idea of being able to revoke that charter if they're not being good corporate citizens? Just interested to hear what your thoughts are on that.
Well, it's a great question, Karen. And the truth is every state retains a power that's known as the quo warranto power, which is the power basically to rescind any corporation's charter, any corporation that's chartered in that state at least. So that is a tool that is available to attorney generals or attorneys general in different states. But it is definitely a tool that has withered on the vine of disuse or lack of use over the years. And we've seen very, very few efforts to use it. And to the extent it has been used, it's really only been used against very small companies, sole proprietorships or something that have basically engaged in widespread fraud. But that is a power that if reformers wanted to take seriously, they could start to try to reinvigorate this doctrine. States, the law, even constitutional law, is pretty clear on this issue that states retain a lot of authority over whether they're going to allow a corporation to be chartered in that state or not. And that's something that states can use more effectively, I think, than they have in the past.
There were some questions and comments put in chat as a follow-up to the rights of nature consideration in the sense of it rising to the Supreme Court. People had mentioned our children's trust case about trying to expand the public trust doctrine to include environmental protections. There was a lower court decision in the federal courts that recognize a constitutional right to a livable climate. That case is still out there, and so it hasn't made it through, in the essence, to the highest levels. But someone had asked if rights of nature is too radical of a concept. What's the possibility of a right to live in a natural and unpolluted environment, making it into being a recognized constitutional right? And if so, how does that play against corporate constitutional rights when you may have a conflict of rights coming in where we have a right to a livable climate, yet corporate rights are claiming we have a right to make profit and to pursue things of which actually destabilize the climate. So maybe there's a couple questions in there. That right to climate idea rising to that highest federal constitutional level, and then if it were to be enacted, what's that conflict potentially look like?
I mean, I think it's like any conflict of rights, you know, that's a lot of what these court cases are about, with nature or not. I mean, so if someone's rights infringe on someone else's, then the court has to decide. But I do think, yeah, the U.S. is lagging in this. I think there's countries around the world that are enacting these kinds of right to climate laws, because, you know, they see what we should all be seeing, which is that we're in pretty desperate straits when it comes to climate change. So, you know, and then if you're a court and you're not, you know, beholden to corporations, and you're weighing the right to continue to live with the right to make profits for your shareholders. I mean, I know which way I would decide, but that's why I'm not on the Supreme Court. So, yeah, I think that there are a lot of models that are moving in that direction, a lot of countries that are recognizing those rights, and hopefully we can catch up.
And the question really calls for one of the reasons why we need a Supreme Court that's willing to rethink its approach to corporate rights, because yes, the courts do balance rights against each other, but I don't think there should be the same equivalence of rights between you and me and the corporation. And corporations, I think, probably need some basic protections in the law. We shouldn't want corporations be found guilty of crimes without a trial, without evidence, right? We wouldn't want corporations' property just seized by the government and then taken away without any compensation in most circumstances. But we don't need to give corporations all of the expansive rights that they have today. And we don't need to give corporations the ability to engage in activities that hurt us. Generally, courts say that you have a right, but your right stops where my nose starts. You know, you can't hurt me by the use of your rights. Unfortunately, corporate rights haven't been so limited.
There were some additional questions that came out of the discussion on chartering of corporations, the idea of where they're chartered. And then there was a kind of a two-part question about, you know, the fact that a lot of corporations incorporate in Delaware. And then a follow-up question that is, were you talking about the ability of a state to not recognize the charter of a corporation chartered elsewhere? So getting some clarity on this idea of how corporations are chartered and whether or not pursuing the path of trying to uncharter a chartered corporation is what that looks like, and whether, I guess, it's a feasible path to take.
Well, it's a great question, and it's definitely true that there are daunting hurdles, that many corporations, especially many of our most powerful corporations, are chartered in Delaware. And part of the problem, and the reason why they're chartered in Delaware, is in part because there's been this race to the bottom by states that are seeking corporate money by offering the most lax rules to regulate corporations. But what we really need is a race to the top, where we need states that are fighting amongst each other to have the best regulations of corporation, not just the loosest regulations of corporations. I don't expect Delaware to turn around anytime soon and start using the quo warranto power to stop corporations from being chartered in their state. But we need to start a political movement. There are no easy answers here. There's no simple switch we can pull and going to overturn 200 years of constitutional history and corporate power in America. You got to fight on all levels and fight everywhere. And it's definitely a challenge. And there's a reason why the quo warranto power hasn't been used in some circumstances, is because of places like Delaware have many of the powerful corporations, but it's not restricted, right? There's California, there's a lot of California big corporations out there, a lot of big oil, some big oil companies that are chartered in California that California could go after. But it is a multi-pronged strategy to fight corporate power, for sure.
Yeah, it makes me wonder, just in the sense of movement building, we've clearly seen corporations use the courts. They haven't marched on the streets, as you pointed out, but we've seen ways of which politics, movement building, legislation, and legal arguments have kind of merged when it's come to marriage equality. In a weird way also with marijuana legalization, you have states instituting the legalization of it against federal law. So just the idea that pushing from the bottom up and even, empowering states to have a different view of corporations, even if it's in conflict with the federal level, if you have multiple states doing that, does that begin to change the tide, so to speak, around this idea of corporate constitutional rights? Looks like we got a couple more questions before we probably need to wrap up. This next question is, since corporate rights have been used to bolster arguments for the rights of nature, would limiting corporate rights make it more difficult to justify rights for rivers, ecosystems, etc.?
I don't think so. I mean, I think that it's much harder. I mean, just on a logical level to understand the right of a corporation that doesn't exist except on paper versus a living entity like a river or an ecosystem. I mean, that's just my intuitive understanding. I don't think getting rid of the legal fiction of corporate rights does harm to rights of nature. And I mean, there's other entities like children that have some rights, but not others. So, you can't sue a child, but a child has certain rights. So I think there's other models besides corporations that can still be pointed to.
This kind of went back to the question, I guess, of the movement orientation around how you transform very staunchly protected realities in our legal system, in this case, corporate constitutional rights. This question is, any thoughts about how the courts are pushed by the citizenry/culture to update or go contrary to precedent that has perpetuated decisions like corporate personhood? So, what role has people pressure played on the court's decisions, if any, through our history?
Oh, I think it's so important. It's so important. It's not always the case. Corporations have won their rights without a popular movement to pressure the courts to do it, in parts because the courts are pretty business friendly and they represent the most elite privileged members of society as a general matter. But we've seen over and over again in American history, and we think about the civil rights movement. The Supreme Court fought against racial equality tooth and nail for decades. And it was we the people that pushed the Supreme Court in the civil rights movement to change its approach. Look in more recent times about LGBTQ rights. When I was in law school back in the early 1990s, I think if people said that there was a right to same-sex marriage in the Constitution, that would have been thought to be a radical or a crazy idea at the time, off the wall perhaps. But today it's as on the wall as you can imagine. And that's because of a social movement that's pushed for those rights and made it clear that we can't have equality in our country if we don't have equality for LGBTQ people. Gun rights is another area, right? The Second Amendment, right, has been completely transformed over the last 30 years, 40 years by the NRA and others through a popular social movement, not a liberal or progressive one, but nonetheless a popular social movement that's changed our understanding of the Constitution and mobilized citizens in state after state after state, winning legislation, winning court rulings. The DC versus Heller, the Supreme Court case was decided in 2008, was the first Supreme Court case to rule unambiguously that there was a right to have guns, individuals to have guns under the Second Amendment. That's 2008. That's a long time after the founding. And why? Because there was a mobilization and people changed American culture. And that's what has to happen in the field of corporate rights too. And if we do that, then we'll get the Supreme Court that has the right attitude and that rules properly on corporate rights. And we'll have legislation that reflects that, hopefully, as well. It's going to be a tough battle, but you've got to change the hearts and minds if you want to change the Supreme Court.
There was a question going back to what you said earlier, Adam, in regards to sort of corporate protections, whether they need to be actually articulated, through the term rights, or if there's other means to allow corporate actors out there to do business, so to speak, but not to carry corporate constitutional rights in the same way as people. Would you say that what you said was really something in the realm of rights, or something of just expanded protections that doesn't fall under rights in the same way that the Bill of Rights is supposed to apply to natural persons?
Yeah, there are other ways to do it. You could do it through legislation, perhaps. You could have legislation that says that corporations have basic property rights, are entitled to a jury trial if they're charged with a criminal offense, right to basic due process if they're charged in a civil case by the government. But you do have to be concerned about things like newspaper corporations, about media corporations. Should they have a First Amendment right? I have no doubt that we've seen some politicians in America in recent years that if they got the chance to censor the New York Times or CNN, they'd eagerly jump at that chance. We've seen over American history, the state of Alabama tried to put the NAACP out of business because it was a corporation, saying that they had control over corporations and could stop that corporation from operating in Alabama, fighting for segregation. We do have to be cognizant that if you totally restrict corporate rights and leave it up to lawmakers, they may be in any particular instance corporations that should have rights that won't have them at that moment. That's just something that you have to balance and figure out and add to the calculus in deciding what kind of reform you really want and how to achieve it.
There was a question, just for clarity purposes, that we've been talking corporation without, I guess, defining often what we mean, that we've pointed to large corporations and large industries. But someone's asking, I guess, in the realm of corporate constitutional rights, is there any difference between a 1 or 2 person corporation versus a large corporation with a board of directors when it comes to those type of constitutional rights?
I don't believe so, but I'll let the professor correct me.
There's no correction necessary, like the material, and there's no difference there. In the Hobby Lobby case, where the court said that Hobby Lobby, a privately held corporation, had religious freedom rights under a federal statute, and thus was entitled to an exemption from a requirement that it provide birth control to its employees. The court suggested that public companies might be treated differently under this rule, might not have religious freedom, but the court didn't really suggest a reason why. It more or less said that we just don't think that public companies will claim religious freedom rights. So as a result, we've seen a lot of constitutional rights cases dealing with things like free speech and with religious freedom to come from privately held corporations. But the truth is, there's lots of different kinds of corporations, as we mentioned earlier. The Supreme Court has done a very poor job of differentiating among those corporations. And it's used cases like the NAACP case to say, well, if the NAACP has a right of freedom of association, then so do the big businesses that are spending money on political ads. So the court has often failed to recognize the variation in different kinds of corporations that might require different treatment and different legal regimes.
We're just about at time. Adam or Karen, if you both have information links, contact links, additional resource links that you want to drop in chat, please do so. And we'll include those links as part of the post-production from the recording tonight. So when the video is available, people have that access to it. Also, just to mention that the Oregon Community Rights Network is attempting to do some of this movement building work to counter corporate power. They're working on a constitutional amendment that would secure rights of communities to make decisions over that of corporate interests, to push back on other legal doctrines like state ceiling preemption. So there are mobilizations in places like Oregon to try to redefine how government is ordered. And for people who want to know more about what's happening there, you can reach out to the ORCRN through the website or Facebook or through info@orcrn.org. I think we're at time. Really appreciate, Adam, your time tonight. Karen, you as well, coming in from the East Coast here, so much later for you at the moment than the rest of us that are on the West Coast. Again, really appreciate everything that was shared tonight from the two of you, from all the people attending. I hope we found this valuable. We're looking to do more of these types of events in the future. So thank you very much, everyone, for being here, and really, again, appreciate Adam and Karen, your time this evening.